DJM Land Company versus Mitchell Kish.
Good morning, Your Honor. For the record, Stuart Collis, P49530 on behalf of the plaintiff. Mr. Kish
I
is.
think I do. Mr. Kish?
Good morning, Your Honor. Mitchell Kish here.
Good morning. All right. And what is plaintiff's claim in this case, including cost?
Your Honor, including costs, that would be $6,477.40.
All right. And, sir, how are you intending on getting this paid if you believe that it's owed?
I've made a partial payment. They received a check they should be in possession of for a partial payment for it, which should be leaving me a balance near $5,800. And I should have that paid within about 7 days, next week on Friday.
You're entitled to an adjournment on this, so I will adjourn this matter out. You think that you're going to have the balance paid by then?
Yes, yeah, I do.
All right. I will adjourn this to May 30th, 2025 at
1 p.m.
At 1 p.m. That is an in-person proceeding. If it's not all taken care of.
Sounds good. Thank you.
Thank you, Your Honor.
All right. Thank you. Court calls the case of Avalon Housing versus Yolanda Shepard.
Morning, Your Honor. Jillian Engen for plaintiff.
Good morning, Your Honor. Andrew Campbell, P64391 on behalf of Yolanda Shepard. Last night, Your Honor, I filed several pleadings, Judge. The matter is a little bit complicated, and I'm not sure if you would, if opposing counsel will be better to describe what's going on.
Your Honor, it's my understanding that there was a flood in the unit. And so I think that the parties are attempting to resolve this. However, my client needs to go in and complete repairs. And so we're trying to coordinate retrieval of Ms. Shepard's belongings. We're trying to figure out kind of how to move forward. But my client does need to get into the unit and ensure that, there's not going to be entry by Ms. Shepard. And so we filed the ex parte motion with that intent that the court would give authority to plaintiff to remove and secure defendant's personal property and then dispose of anything that was damaged that's in the leased premises.
And
May I
what
add?
I'm sorry. Go ahead.
Yeah, if I may, Your Honor, just to add to that a little bit. We had a 10-day meeting, Your Honor, and my client was living with a neighbor after this flood. And then May 8th, the county came in and put a tag up and locked everybody out. May 9th, opposing counsel emailed me because the day before I had emailed them asking about the case. And they sent me the pleadings and also the notice to quit and the health hazard. Now, those were served, Your Honor, just so you know, on the same date that these pleadings were filed. So I filed yesterday a motion to dismiss for lack of jurisdiction and a response to the defendant's motion, as well as an answer and affirmative defenses. We are trying to work with them.
Well,
we're not.
Let's deal with the jurisdictional issue. What is your jurisdictional issue?
Well, Your Honor, it's my understanding that MCL 600.5714 states a person entitled to possession of premises may, meaning it's permissible, to recover possession by summary proceedings after a person holds over premises. So to hold over, you have to be served the notice to quit. If you send a 30-day notice, you got to send it, give them 30 days to comply, and then file your summons and complaint. Or in this case, they did both a 30-day TOT notice and a health hazard notice, but they sent the health hazard notice on the date of filing. And respectfully, I think that that's violating the law because you're supposed to give them 7 days to get in. And frankly, that's hard to do so when the county has locked you out. And so the court lacks jurisdiction because the requisite requirements by the statute were not met prior to filing. And I listed all the law in my brief, Your Honor, in my motion. Ypsilanti Housing Commission versus O'Day. Plaintiff's termination notice is improper and void. And also Park Forest versus Smith, a proper termination notice is necessary for the court to have jurisdiction. And while the notice was valid in respects to perhaps the content, although we disagree with the assertions, it was not timely. It was not filed in a timely manner. And so my client never had a chance to kind of abide by the demands of the notice. And additionally, I filed a motion for discovery if the court was not going to grant it, because the fire report indicates, I'm quoting from page 1, incident type sprinkler activation, no fire, unintentional. It also states, quote, there was no fire or smoke in the building, end quote. So my client, she wasn't responsible. Apparently this sprinkler, I haven't been in the apartment because we're locked out, but it's cathedral ceilings. It's way up. My client tells me she can't even reach it with a ladder. So the sprinkler just went off and caused all this water to be ejected. She's been, and Avalon has been assisting. They did offer a hotel, but she couldn't get transportation to the kids for school, so she stayed with a neighbor. Now they're offering a hotel again, which we're grateful for, and we want to take advantage of. But my client is poor and doesn't have a lot of money and needs to be able to get a U-Haul and a storage unit. So she went to Faith in Action and should be hearing from them today.
Why are we going through all of this? It's the unit is untenable, correct?
Well, that's the conclusions they state. They're stating it's untenable, and I don't know I don't know for sure. I don't see any insurance adjusters reports. I don't see anything. There was an inch of water.
I guess I'm not even clear why we're going through this. Under paragraph 31 of the lease, the landlord wants to enter the premises to secure the premises.
Yes, but there's a couple problems with the order. And the order that they proposed, Your Honor, let me get specific. And because I've been through this before. I've been down here for 3 months, and I've seen this before. And it says, it's further ordered that plaintiff may remove and secure defendant's personal property from the leased premises. And here's the problem language. Dispose of any rubbish, trash, waste, and other water damage and or flood damaged items contained in the leased premises. That's a problem because any maintenance person.
Then why don't you just ask that they can just that your client can look at it? I mean,
that's what I did in my motion that I filed.
Don't interrupt me. Why are we going through all of this? They need to get into the premises. They tag the unit. They need to get into premises. Otherwise, more damage is going to occur, both to your client's property as well as to the tenant, to the unit. Doesn't make any sense to me why we're going through all of this.
I'm sorry.
If the issue becomes the destruction or the disposal of property, then certainly I think counsel should be able to arrange that as the property is being removed, your client can be there to try to salvage what property is salvageable.
May I speak, Your Honor?
Go ahead.
I apologize for interrupting the court.
Judge Simpson is separating two issues that defense counsel keeps blending together: whether the eviction complaint was properly filed and whether the landlord may immediately enter a flood-damaged unit. The jurisdictional challenge could ultimately matter because counsel argues the required termination period had not expired before filing. But that does not eliminate the urgent need to prevent additional damage, especially when the county has already tagged and locked the unit. Notice what hurts the defense presentation here. Counsel has potentially serious statutory and property disposal objections, yet repeated interruptions and resistance to coordinating access make a protective argument sound obstructive. The judge's "don't interrupt me" warning signals frustration with advocacy that is no longer helping resolve the emergency. At the same time, Judge Simpson does not simply grant the landlord's proposed ex parte order. He recognizes that allowing maintenance staff to decide what property is water damaged could create a separate dispute over wrongful disposal. Would you trust one side alone to make that decision? The likely solution is controlled access involving both counsel, the county, and the tenant, a practical order that preserves property without deciding the possession case prematurely.
Judge, there's a lot of issues in this case. If you look at my motion, my response, the problem we have is we want that, Your Honor. We asked at the 10-day meeting for opposing counsel to contact the county and get the county's schedule when they can come out and open the door for my client. And my client can then go in. Nobody can enter without the county's permission, Judge. Okay? That's what we want. But what we don't want is we don't want some maintenance person looking at the goods and saying, oh, that's water damage.
Why don't you and counsel get together, contact the county, and arrange a time to go down?
I agree.
What is so hard? What is so hard about that?
There's nothing hard, Judge. It's not on me to do that, Judge. It's a plaintiff's case. And we had a meeting. And
Counsel. Your client has property that she may want to salvage. It would seem to me that it would be in your interest to contact plaintiff's counsel, get with the county, figure out a time that the parties can go in there. It's in all parties' interest to do that. Your client, the landlord, everybody's interest to get into the unit, get out those items that your client that are salvageable, allow the landlord to go in, repair what's there so that further damage doesn't occur.
I agree. And that's why we had a 10-day meeting.
All right, here's what we're going to do. I'm adjourning this to next week. Between now and next week, I'm going to order that council get together with the county, arrange a time to go into the premises for inspection of the premises and removal of those items.
Thank you, Your Honor. And so at this time, I just want to clarify, Your Honor, you're not entering the ex parte order as drafted.
I'm not going to enter that order. I'm going to enter the order directing the parties to get with the county, to gain entry to the premises. That defendant is to remove those items that she wishes removed.
Thank you.
And then plaintiff is also able to secure the premises and stop any further waste on the premises.
Thank you, Your Honor. Two things briefly, Your Honor. We would like to reserve escrow or preserve escrow from today's date. Also, the case was filed under 657-14 1C 1i after termination of the lease pursuant to a power to terminate provided in the lease or implied by law. Obviously, we can talk about that later. I just want to have that on the record.
Well, that's why I don't see the jurisdictional issue, because I think it's properly filed pursuant to the provision in the lease, but we can argue that at another point. But I'm ordering that, and I'll set this for May 30th, 2025 at 3 p.m. That's in person.
Thank you, Your Honor. Would you like us to submit an order to the court in accordance with?
Please.
In person didn't mean I was supposed to be here. I wasn't even supposed to be here.
Thank you. Glencoe Hills versus Justin Jefferson.
Jillian Engen for plaintiff.
Justin Jefferson, there is no response. And I also should say, is it Unganchuku Nasiki? Nasiki? No response. If you'd raise your right hand, I'll let you proceed. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth? So help you God.
I do.
Go ahead.
Thank you. This is a case for non-payment of rent. Rent to retain possession is $3,494.56. Court costs are $212 for a total of $3,706.56. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days. Do I have is after June 2nd?
Judgment to the plaintiff, that is by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Court calls case Glencoe Hills versus Devonta Jackson and is it like China?
It's LaChina. You can call me China.
Say it again for me.
It's LaChina. You can call me China.
Okay, it's LaChina. Okay, I'm sorry. I didn't know where to break apart the syllables. LaChina Williams.
You got close enough.
Okay. All right. What is the claim in this case?
Your Honor, I have a balance including court costs of $1,818.50.
And LaChina, when are you going to get that? How are you going to get that paid?
I can get that paid by the 1st.
By the 1st?
Yes.
Okay, so here's our problem. I can adjourn it out a week, but the 1st, June rent is gonna click in.
Oh, is the 30th okay?
Can you pay it on the 30th?
Yes.
Okay. Here's what we'll do. I'll adjourn this out to May 30th, 2025 at 3 p.m. That's an in-person hearing. So can you get that paid? Can you get that balance paid, say, before noon that day?
Yes.
Oh, okay, fantastic. Okay, so if you get it paid before noon, then what likely will happen is that plaintiff will dismiss the case. But you may want to check with them, make sure you got everything paid.
Okay.
Okay?
All right. Thank you.
Thank you. You have a great weekend.
You too. Bye-bye.
Court calls the case of Glencoe Hills versus Daniel Wirth.
Jillian Engen, plaintiff.
Hello.
Hello, Mr. Wirth. Do you have a camera?
Yes.
Okay, I'll need you to turn that on, but while you're doing that, oh, you got it on. Okay, what is plaintiff's claim in this case?
Your Honor, I have a balance including court costs of $3,067.63.
All right, Mr. Wirth, how are you intending on getting that paid?
I have a payment plan that covers next month rent, but it wouldn't be, my balance would be at 0 by next month of the 30th.
Okay, have you talked that over with your landlord?
Yeah.
Your Honor, I don't know that plaintiff is willing. I don't know if we're willing to do. I don't know if plaintiff is willing to do a COD on this one. I can ask my client.
All right. So here's what I'll do, Mr. Wirth. Is there anything you can pay between now and next week?
I could do, what does next week fall on?
The 30th of May.
I could pay 1,500.
1,500 by that day?
Yeah.
Okay, so let's do this. You need to pay 1,500 by the 30th. I want that paid before noon on that date, okay?
Okay.
Then I'm going to adjourn this to May 30th, 2025 at 3 p.m. That's an in-person hearing. And then we'll see where we go from there, okay?
Could you do June 2nd for the first payment?
I cannot.
Okay.
Because if you're not gonna, if you can make the payment, you need to make the payment, sir.
Okay, I'll make the payment. I could make it by June 2nd with that 1,500.
All right. Well, I'll put that in the file, but I'll still need you here then on the 30th
Okay.
at 3 p.m.
Okay, thank you.
You. Glencoe Hills versus Daniel Reynolds.
Jillian Engen for plaintiff.
Here.
Mr. Reynolds?
Yes.
Okay, there you are. All right. What is plaintiff's claim in this case?
Your Honor, I have a balance, including court costs of $2,068.70.
All right. Mr. Reynolds, how are you intending on getting that paid?
So approximately $750 I could pay by Wednesday of next week, and most of that today. And then that will leave me with my normal rent for the month of May, which I can make another partial payment on May 30th, but it wouldn't be the full amount of May on May 30th. I'd need approximately a week to 2 weeks to catch that up. And then I know I'll be due for June.
Hold on a second. You're going to pay $750 by the 28th. That's next Wednesday.
Yes. And that'll just
All
leave
right.
me with May.
Okay. And then on the 30th, how much did you say you're going to pay?
I'll be able to pay roughly $600.
Okay. And then $600 on the 30th. I'd like that paid to the landlord before noon. Okay.
Sure thing. Yes.
And then I'll adjourn this out to May 30th, 2025, 3 p.m. That's in person. So then we can see where we can go from there, okay?
Your Honor, would it be possible for an alternate viewing? I will be in Chicago on next Friday.
Okay, that's the time that I've set it in person. You could submit a form to the court requesting a Zoom hearing, and then we'll consider that.
Okay, and what is the best way to submit that? Do I go to the court, or is there an electronic version I could use?
You could, my coordinator will put her email in the chat, and so you can make that request directly there, okay?
All right, thank you.
Thank you. Gulfside Lakes versus Sarah Brown and Jalen Brown.
Jillian Ingram for plaintiff.
Good morning, Your Honor. I'm here.
Good morning. Your name?
Miss Sarah Brown.
You're Sarah Brown. Okay.
Yes, sir.
You got it? Okay. And what is plaintiff's claim?
Your Honor, I have a balance including court costs of $3,473.47.
All right. And ma'am, how are you intending on getting that paid?
That's not the cost that I have. I don't know if they received the $2,400 that I paid last night.
We wouldn't.
Okay.
No.
Okay.
You would not have.
That would
So you
make
paid
difference.
$2,400 last night?
Yes.
Okay. So I'm going to indicate that was the 22nd. You paid that.
Yeah.
And then, so that
yeah.
leaves you about 1,000 and some change. So when were you going to get the balance paid?
I could pay the balance by either in the evening on the 30th or early morning on the 31st.
Okay. So it looks like there may need to be a COD if you can't get it paid by noon on the 30th is what you're telling me.
I can try. I don't want to make that promise because my money hit different times, if that makes sense. I'm sorry.
No, that makes sense. I got you.
Because sometimes it hit earlier in the day, then it'd be in the evening. It's crazy times. I'm sorry.
Okay. All right. So here's what I'll do.
Okay.
I'll let them try to get their accounting and get your ledger all caught up. I'll adjourn this to May 30th, 2025, 3 p.m. That's an in-person hearing. And then we'll try to figure out how we're going to work it out if it's not paid by then.
Okay. Can I
All
get that? May I get that balance again she has so I can minus the $2,400 from it so I'll know what I owe, if that's okay?
Yep. Yes. And I have $3,473.47. You can also contact Melissa.
Okay.
She'll give you
Okay. Yeah. And I'll definitely try to have that paid before 3:00 on the 30th. Thank you, Your Honor.
All right. All right. Thank you. Gulfside Lakes versus Lakia Williams and Karan Williams.
Jillian Ingram for plaintiff.
Hello, Your Honor.
Hello. All right. And Ms. Williams, do you have a camera?
Yes. Hold on.
All right. I'll need you to turn on your camera. And what is plaintiff's claim in this case?
I have a balance including court costs of $3,593.26.
Oh,
All right. Ms. Williams, how are you intending on getting that paid?
So I can have about 593 next week, but I am also in the process of working with Hawk.
Okay. So you're working with Hawk?
Yes. I had an appointment with her yesterday.
You have an appointment with them yet?
Yes, I had one yesterday at around 1 p.m.
Oh, you did?
Mm-hmm.
Okay. They haven't indicated anything then to you?
No, she, what was her name? I think Alicia. She said she's working on it.
Okay, so here's what I'll do. I'll adjourn your case out May 30th, 2025, 3 p.m. That's an in-person hearing, and hopefully we can have some news from Hawk. Try to figure it out. I suggest that you make the payment that you're going to make so that if there's funding there, you'll be below the limit that can get paid, okay?
Yes.
All right. Okay.
Thank you, Your Honor.
Thank you. Gulfside Lakes versus Alicia Sarr.
Jillian Ingram for plaintiff.
She's here. Sarr?
Hello.
Hello, there you are.
Hi.
Okay. Hello. What is plaintiff's claim in this case?
Your Honor, I have a balance including court costs of $219.14.
$219.14.
Yes, sir.
Okay. All right, Ms. Sars.
Yes.
When do you think you can get that paid?
So I made a payment arrangement to pay the rest of it tomorrow with the landlord.
Okay. So you're going to have everything paid. If I adjourn it out a week, everything should be paid.
Yep.
Okay. Then let me do that. I'm going to adjourn this to May 30th, 2025 at 3 p.m. That's in person. But if everything's paid, it's likely they'll dismiss the case and then you don't need to appear.
Oh, no, okay. Thank you.
Okay? All right.
Yep.
Take care. Have a
Okay.
good weekend.
Thank you too.
Court calls the case of Gulfside Lakes versus Erica Hall.
Jillian Ingan for plaintiff.
Hello.
Hello.
And I got it right. So, and you know what? You didn't even say, good job, Judge. You didn't say anything. I got it right. I'm just saying that because I'm proud of me. So, all right.
The win.
All right, Ms.
The
Hall.
win.
All right. How much is owing?
I have a balance including court costs of $2,749.29.
Said 2749.
Yes, sir.
All right. Ms. Hall, how are you intending on getting that paid?
Can have everything paid by the 13th of June, but I know that's pushing it. I can make a payment of $600 by next Friday, and I'm taking out a personal loan, but it takes a few days for that to go through.
To get through.
Yeah.
Okay, so let's do this. Pay the 600 by next week. I'll just put by the 30th if you can pay that early in the day. And then I'll adjourn it out to May 30th, 2025 at 3 p.m. That'll be in person. And you might want to contact the attorney's office, see if they, since you know that you won't have it paid before the 13th of June, to try to work something out regarding a COD or something to get that in June encompassed. Got it?
Okay.
Okay. All right.
All right.
We'll see you next week. Take care.
All right. Thank you.
Court does call the case of Gulfside Lakes versus Emmett Redwine.
Jillian Ingan for plaintiff.
Hello.
Hello, Mr. Redwine.
How you
All
doing?
right. I'm doing okay. All right. How much is owing?
I have a balance including court costs of $3,009.28.
All right. Mr. Redwine, how are you intending on getting that paid?
I'm gonna pay something Friday. I'm gonna pay something Friday, then I'm gonna pay another 1,600 2 weeks after that. Then
Okay. So how much can you pay by next Friday?
I'm pay $750 Friday. It's Friday.
Okay. So $750 by the 30th. It looks like something's gonna have to be worked out regarding a payment plan or something, if it can be. So then I'll adjourn this out May 30th, 2025 at 3 p.m. That will be in person. And then we can see if we can get something worked out. Okay, Mr. Redwine?
Okay. What time?
All right. That's at 3 p.m.
Okay, thank you.
Thank you. Court calls the case of Gulfside Lakes versus Michelle Goble and Marlon Goble.
Jillian Ingan for plaintiff.
Good morning. This is Michelle Goble.
Okay, good morning. All right. How much is owing on this account?
I have a balance including court costs of $1,643.74.
All right. Ms. Goble, how were you intending on getting that paid?
Yes, I get paid every other Wednesday. So I was planning on doing about 600 on the 28th and then the remaining balance on Wednesday, June 11th, both before noon.
On June 11th?
Yes.
But is that that's going to include your June rent or no?
I think so. Yes, yeah.
All right. So here's what I'm going to do. You said you can pay 600 by the 28th.
Yes, sir.
All right, get that paid. I'm going to adjourn the hearing to May 30th, 2025 at 3 p.m. That's an in-person hearing. And I'd suggest that you contact plaintiff's attorney's office, see if you can work out some type of either conditional order dismissal or something regarding this case. Okay?
Perfect. Thank you so much.
All right. Thank you. Have a great day.
Again, you too.
Gulfside Lakes versus Mia Salvano.
Jillian Ingan for plaintiff.
Mia Salvano, no response. You've been sworn. You may proceed.
Thank you, Your Honor. This is the case for non-payment of rent. Rent to retain possession is $2,784.07. Court costs are $172 for a total of $2,956.07. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Can you give me that amount again?
Yep. $2,956.07.
Got it. Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested. Writ to issue in 10 days. Hamilton Crossing 2 versus Tanisha Ballard.
Jillian Engen for plaintiff.
Tanisha Ballard. I do not have her. You may proceed.
Thank you, Your Honor. We're actually looking to do a conditional order of dismissal with this one. I can place terms on the record, and it's going to be submitted to the court.
Okay.
Okay, so defendant may retain possession of the leased premises through the end of the lease term, provided that defendant complies with the following terms. As of May 9th, 2025, defendant has an outstanding arrearage of $2,178, includes $172 in court costs. Plaintiff shall pay the outstanding arrearage as follows. And I realize that some of these dates are before today's date. The payments have already been made in compliance with this. $300 on or before May 10th, 2025, $285 on or before the 10th of each month from June through November, and then $168 on or before December 10th, 2025. And then defendant shall pay monthly rent in the amount of $772 on or before the 25th of each month, commencing May 25th, 2025, and continuing through December 25th, 2025. And then commencing January 1st, 2026, defendant shall pay monthly rent timely. Defendant shall comply with the terms of the lease.
All right. So I see those certainly as more favorable terms than the entry of a judgment in this case. So I'll enter the COD when it's presented with those terms.
Thank you, Your Honor.
Hamilton Crossing 2 versus Joshua Meyers. And is it Sheriff Meyers?
Sorry, Your Honor. Okay. Jillian, for plaintiff, Your Honor, we have a conditional order of dismissal for this case as well. I can place terms on the record.
Go ahead.
Thank you. Okay. Defendants may retain possession of the leased premises through the end of the lease term, provided that defendants comply with the following terms. As of May 9th, 2025, defendants have an outstanding arrearage of $5,189, which includes $214 court costs. Defendants shall pay the outstanding arrearage as follows: $415 on or before May 10th, 2025, $181 on or before May 25th, 2025, $415 on or before June 10th, 2025, $415 on or before August 10th, 2025, and $260 on or before September 10th, 2025, $415 on or before October 10th, 2025, and continuing with $415 per month on the or before the 10th of each month through April 10th, 2026, $28 on or before May 10th, 2026. And then defendant shall pay monthly rent in the amount of $772 on or before the 25th of each month, commencing May 25th, 2025, and continuing through May 25th, 2026, commencing June 1st, 2026. Defendant shall pay monthly rent timely. Defendant shall comply with the terms of the lease. So,
and I do see those terms as being more favorable than an entry of a judgment by default. So the court will enter the conditional order of dismissal.
These conditional dismissals reveal the most important strategic difference in this docket. A repayment agreement can protect a tenant far better than an immediate possession judgment, but only if every deadline is realistic. Judge Simpson expressly calls these terms more favorable because the tenants remain in possession while paying current rent and reducing arrears over time. Unlike a judgment, the case is conditionally dismissed. However, the protection depends on strict compliance with the recorded schedule and lease. That is why the detailed dates and amounts matter. A missed installment may revive the landlord's enforcement options without requiring the parties to renegotiate from the beginning. From the landlord's perspective, this structure converts an uncertain collection problem into an enforceable payment roadmap. From the tenant's perspective, it avoids the immediate eviction track and creates time to stabilize financially. But look at the duration of the Meyers plan. Payments extend into 2026 alongside monthly rent. Is that sustainable, or does it create another default risk? The strongest courtroom strategy would be to confirm income, payment dates, and assistance before accepting terms, because an agreement that looks generous on paper can become dangerous if the tenant cannot actually perform.
Court does call the case of Huron Vista Apartments versus Wilbur Burell.
Jillian Engen for plaintiff.
Mr. Burell?
Yes.
Okay, there you are. You're at our access point here.
Hello?
Hello?
Oh, can you hear me?
Yes, I can hear you.
Okay.
Can you hear me, Mr. Burell?
Yes.
Okay. I don't have a camera on. I'm not sure why that is the case, but what is plaintiff's claim in this case?
Your Honor, I have a balance of $1,525. I also have a note from my client that Mr. Burell is participating in the Huron Vista forgiveness plan. So I think that we should be putting together a conditional order of dismissal.
Okay. Is that your understanding, Mr. Burell?
Yes, sir.
All right, so here's what I'm gonna do, sir. I'm gonna adjourn your case out to May 30th, next Friday, 2025 at 3 p.m. That's in person, so you'll actually come into the courtroom and hopefully we can have everything worked out.
Okay, yeah, because I talked to the landlord. He told me the terms and the condition to make sure I pay this 3 months and then get help from my SER, from my DHS broker.
I understand the program over there at Huron Vista. So they just have to work out the paperwork and we'll have to enter the paperwork next week, okay?
Okay.
All right, we'll see you then.
Okay. What day you say? Next Friday at 3 o'clock?
At 3 o'clock, yes, sir.
All right, thank you.
Thank you. Court calls the case of Huron Vista versus Alicia Moore.
Jillian Ingen for plaintiff.
Huron Vista versus Jacqueline Taylor and is it Tania Taylor?
Good morning, Jefferson.
Good morning. And who I'm sorry.
Jacqueline Taylor. This is Jacqueline Taylor.
Okay, gotcha. Okay. All right. What is the claim in this case?
I have a balance including court costs of $2,194.03, and I don't have any notes regarding the forgiveness plan.
All right. Okay, Ms. Taylor, how are you intending on getting that paid?
I'm going to pay something next week. I had got an email about the forgiveness plan, but I didn't get the letter about it because I fell on the property. That's how I got behind in my rental payments, which I told them. I fell, and then I had to take off of work because I hurt my wrist and my knee.
Okay. So I don't know, is she eligible for the program or you don't know, counsel?
I'm sorry, I'm not sure.
Not sure?
I'm not sure. That would have to, but I will ask.
All right. So, Ms. Taylor, have you reached out to the landlord regarding the forgiveness program or not?
I can email today. I will email today when we're done.
Perfect.
Okay. Then here's what I'm going to do. How much do you say you can pay?
500 by the 30th.
Okay. So I'll indicate that you're going to pay 500. I'll put that by the 30th sometime. I'll adjourn this out to May 30th, 2025 at 3 p.m. That will be in person. Okay.
Okay. Okay.
And then hopefully you'll email them and hopefully we can work something out on that date. All right.
Okay. Thank you so much.
All right. Thank you. Have a good weekend.
You as well.
Huron Vista versus Rodney Taylor.
I have Jillian Ingen for plaintiff.
Mr. Taylor, I'll need a camera, sir. And how much is plaintiff's claim?
I have a balance of $2,223, and Mr. Taylor is participating in the forgiveness plan.
Okay, Mr. Taylor, is that correct?
That's correct. I'm trying to turn my camera on. I can't turn it on. I'm having some problems up here.
Okay, here's what I'm going to do. Since you're participating in that program, we'll need you here next week, May 30th, 2025, 3 p.m. in person. Let's get the paperwork together and get that all in. Okay, sir?
All right, no problem.
Okay, thank you. Oh, see, you got on just at the last minute. Now I know on the 30th who I'm looking for. Your camera's working. You got it. All right?
Yes, sir. Yes,
all right,
sir.
you take care. You have a good weekend.
You too.
Huron Vista versus, is it Charkeisha Roberts?
Jillian Ingen for plaintiff.
Charkeisha Roberts, she's not here. You may proceed if you'd like.
Thank you, Your Honor. I am going to take a default judgment. I have rent to retain possession of $2,816. Court costs are $176 for a total of $2,992. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days. And Your Honor, for the record, Ms. Roberts had indicated that she wished to participate in the forgiveness plan. If she does end up, we'll prepare a COD that sets aside the default judgment.
Got it. Okay. Judgment to the plaintiff, that is by default for possession, redemption amount, in the amount requested, writ to issue in 10 days. Huron Vista Apartments versus Moesha Harrison.
Jillian Engen for plaintiff.
Moesha Harrison, not present. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $2,230. Court costs are $176 for a total of, of $2,406. Plaintiff is requesting a default judgment with the writ to issue for possession only with the writ to issue after 10 days. And also if Ms. Harrison does agree to, she has indicated she wants to participate in the forgiveness plan if I'm sorry, my words are, I haven't had enough coffee today.
Gotcha.
We'll
set aside the default
and
enter that
paperwork. Thank you.
Okay. Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Huron Vista versus Shinar McGra.
Jillian Engen for plaintiff.
McGra, no response.
Thank you, Your Honor. This is a case for non-payment of rent. I have rent to retain possession of $49. Court costs are $176 for a total of $225. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff, that's by default for possession, redemption amount in the amount requested with a writ issued in 10 days, no writ without a hearing. Court does call the case of Huron Vista versus Danielle Davis.
Jillian Engen for plaintiff.
Danielle Davis. They are not present. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $3,346. Court costs of $176 for a total of $3,522. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days. However, if Ms. Davis does agree to enter into the forgiveness program and enters a COD, we will set aside the default in the COD.
All right. Judgment to the plaintiff, that is by default for possession, redemption amount is in the amount requested with a writ to issue in 10 days. Evergreen Apartments versus Abraham Hack.
Hello, Your Honor.
All right, Mr. Hack, he's got his camera on.
Hello.
Right. Hello. All right. How much is owing on this guy?
I have a balance including court costs of $2,823.88. Your Honor, I also do want to note that Mr. Hack has provided a notice to vacate for the end of his lease on June 15th. And so if this case continues till June 15th, we will likely, and Mr. Hack moves out, we will likely end up dismissing.
Is that correct? Is all of that correct, sir?
Yeah, it looks like it's all correct from what I got on the paper.
Okay. Are you going to be able to make a payment before the 30th?
Yes. I should be getting my last paycheck from my previous job before that.
Do you know how much you can pay by the 30th?
I'm locked out of my Alti-Pro that tells me how much I'm going to be paid on the 30th. So I don't have an actual estimation of how much, but I'm trying to save up as much as I can to pay as much as I can, Your Honor.
Okay. All right. I'll adjourn this out May 30th, 2025, 3 p.m. That's in person. All right.
Okay. Just because I'm a little bit slower, can I just the total cost of what I owe just one more time in person at 3 p.m.
The total amount that's they claim is owed is $2,823 was that 88 cents?
88, yes, Your Honor.
And then I was supposed to show up 3 p.m. At what was the address? Is it on the paper that I received at all?
Yes, the court address is 4133 Washington.
4133 Washington.
Right up by the sheriff's department. Okay.
Okay.
All right.
Thank you, Your Honor.
Thank you, sir.
Am I good?
Evergreen Apartments versus Idris Williams. You're all set. Sure.
Jillian Engen for plaintiff.
And Mohammed Al-Duwasi.
How's it going?
All right. Who is this?
Idris.
William, how you doing, Idris?
How you doing?
I'm doing well. All right. How much is owing on this case?
I have a balance, including court costs, of $1,989.60.
All right. And Sarah, how is that going to get paid?
Oh, both myself and my brother, we both recently started brand new jobs. I graduated last month. You wish me a happy birthday and graduation present. I got that all paid up and everything. That previous one paid up. It's just catching up on this 1 month that we're behind now. So I'm literally outside of my job the job. I'm signing paperwork for my new job. Like I was supposed to be here at 9 o'clock. I already went inside and told them I'm going to be a little late. And my brother, he started a new job last week, tiling floors. So he's getting paid a decent amount now, and I'll be getting paid $23 an hour. So it's literally just getting that handled out. We're both still working our other job as well at night at the restaurant in Ann Arbor. So literally it's just trying to get caught up with that 1 month that we are behind. And it was like 1 month and like 200. Yeah.
All right, let's do this. Let's do this before you lose that job that you haven't started yet. I'm going to adjourn it. I'm going to adjourn it out to May 30th, 2025 at 3 p.m. All right, that's an in-person hearing. I'm going to suggest that you contact on your paperwork. You'll see the attorney's office number. Call them and see if you can work something out regarding this back balance. Okay.
Sounds good. Yeah, no, like next month, everything should be cleared up. It's just because I said, I graduated, the whole situation. So literally it's just trying to play catch up. So I really appreciate it.
Like I said, well, congratulations on the graduation. Get in there, get that job.
Yeah.
And let's see if we can get it all worked out by next week. All right.
Yeah, I'm using this degree to work. All right. Have a nice day.
All right. You take care.
Yeah, you too.
Evergreen Apartments versus Walter Herrera and Daniel Alvarado and Randall Romero.
Jillian Engen for plaintiff.
Any of those individuals present? Herrera, Alvarado, Romero. Nobody's present. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $3,611.86. Court costs are $256 for a total of $3,867.86. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issue in 10 days. Evergreen Apartments versus Daryl Simpson, no relation.
Jillian Engen for plaintiff.
Daryl Simpson, not here. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $1,592.04. Court costs are $172 for a total of $1,764.04. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Evergreen Apartments versus Denasia Hamilton.
Jillian Engen for plaintiff.
Hamilton?
Good morning,
Oh, there she is. Good morning. All right. How much is plaintiff claiming is owed?
I have a balance including court costs of $2,084.66.
All right. Ms. Hamilton, how are you intending on getting that paid?
I contacted my caseworker from DHS. I'm just waiting to hear back. And then I also have some other organizations that I'm waiting to hear back so they can put together and see if they're going to help pay.
All right. So have you filed for an SER through DHHS?
Yes.
Okay. So what I would need you to do, I'm going to adjourn this case out May 30th, 2025 at 3 p.m. That's in person. There's a form that came with your packet notifying you of this hearing. That's called a rental assistance form. You'll have to file that with the court by next Wednesday and put your tracking number on that form. Okay?
Okay.
Okay. If you can't find that paperwork, you can use the QR code on the screen or you can call our clerk's office and they'll be more than happy to give you a copy.
Okay.
Your Honor.
All right. Yes.
If I may, I have a note from my client that Ms. Hamilton's SER application was denied. I just wanted to know if she's filed a new one or if she's going to reapply.
Yeah, I filed a new one as of last night.
Okay.
Got it. Okay. All right. So get that information down to the court and then we'll see you next week at 3.
Okay. Thank you.
Thank you. Evergreen Apartments versus John Hudson.
Jillian Engen for plaintiff.
Hello?
Hello, Mr. Hudson. How are you, sir?
I'm doing pretty good. Yourself?
I'm okay, I think. All right. Okay, how much is owing on Mr. Hudson's account?
I have a balance including court costs of $1,291.
All right. And Mr. Hudson, how are you intending on getting that paid?
I'm intending on getting that paid by next Friday.
Okay, so you're gonna get the balance paid by the 30th. Can you get that paid before noon on the 30th?
Yes, sir.
All right, so I'm gonna put that here that you're gonna pay the balance. If you get it paid and make sure everything is paid on your account, it's likely they'll dismiss your case. Okay?
Okay, cool.
So, but I'm gonna adjourn it to May 30th, 2025, 3 p.m. If it's not paid, you need to be here in person, okay?
Okay, sounds nice.
All right, take care. Have a good weekend.
All right, you too. Thank you.
Evergreen Apartments versus Nelsa. Is it Nieves-Montanez?
Yes.
Montanez. I'm sorry.
Jillian Engen for plaintiff.
Hello. Oh, there she is. Okay. All right. And how much is owing on this?
I have a balance including court costs of $3,705.12.
All right. Ma'am, how are you intending on getting this paid?
I told him I was going to pay some on the first, and then SOS was going to help me with the rest of it. But first, I have to pay a certain amount on the first.
I'm sorry. Say that again for me.
I told her I was going to pay a certain amount on the first, and then SOS will help me with the rest because I had to pay a certain balance for SOS to help me with the rest of it.
All right. So you got to get down below the 3,000.
Yes.
Is that what you're looking? Okay, but if that happens on the first, your new rent kicks in, your June rent kicks in.
Yeah, she told me that yesterday.
Okay. So are you going to try to get everything paid by then? Or
yes.
All right, let's do this. I'm going to adjourn it out 1 week, the 30th, 2025 at 3 p.m. That's in person. And whatever you can get paid before that date, let's try to get that paid and also try to figure out exactly where Hawk may be or SOS would be with you on this case.
Did you say
okay?
the 30th?
Yes, ma'am.
I don't get paid until the first. That's why I told her the first.
No, I understand that,
Okay.
but we got to try to figure out, you get a 1 week adjournment, but we got to figure out how to do that. And on the first, your June rent clicks in.
All right.
And I have that amount for the record. It's going to be $5,000. The total will be $5,388.17. So we're looking at least $2,388.17 would need to be paid before if Hawk is paying $3,000.
Mm-hmm.
Got it. Yeah. Okay. All right. Thank you, ma'am. We'll see you next week.
See you next week.
Evergreen Apartments versus Keith Johnson.
Jillian Engen for plaintiff.
Keith Johnson, no response. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $3,176.29. Court costs are $172 for a total of $3,348.29. Your Honor, my client has indicated for Mr. Johnson that they would be willing to set aside the judgment if possession or payment is received by the second. And so I'm going to include under further orders that this judgment will be set aside if paid in full on or before June 2nd, or if defendant moves out and turns.
All right, very good. All right, thank you. Judgment to the plaintiff by default for possession, redemption amount, in the amount requested, writ issued 10 days. Court calls the case of Evergreen Apartments versus Avalon Carter, Majesty Moyer, Myron Moyer.
Jillian Engen for plaintiff.
Any of those folks? Okay. And when you say I'm here, who are you?
Evelyn Carter.
Thank you. All right. And how much is owing on her account?
Your Honor, this is a case for termination of tenancy.
Got it.
Tenants provided a notice to vacate that they were going to be vacating upon leaving on May 4th, and they have not yet vacated.
Okay. Ms. Carter, what's your position on this?
Okay, so they told me that my lease was over on May 3rd, no, May 4th. So I signed that. I'm thinking I have to move because I got a new voucher, new size voucher. I went to RPI. RPI had already paid May's rent and said my voucher doesn't expire until May 31st. So he told me to stay there until May 31st because I was moving already on June 2nd. I already packed up, already got the DTE scheduled to be disconnected, everything. That's all I knew. I didn't know what else to do about it because RPI said that they paid them and the voucher is expiring on May 31st. And your lease doesn't terminate until May 31st on our end. So I called Squawk and they just told me to go to court and see what happens with that since I'm already moving, what to do.
Okay. So what day are you going to be out?
Okay, my voucher starts June 1st, but my moving day to my new unit will be on the 3rd of June. So I already have everything scheduled to be turned off for the 6th of June, but if I can get into the 3rd, that'll be fine.
Okay, so here's what I'll do. I won't enter a judgment today, but I'll adjourn this out to May 30th, 2025, 3 p.m. in person, and then we can figure out a move-out date and everything else on that, okay?
Thank you, Your Honor.
Okay, thank you so much.
This docket shows that Judge Simpson did not apply one automatic result to every housing dispute. He adjourned cases where tenants identified payments, pending assistance, forgiveness programs, or move-out plans, entered possession judgments when defendants failed to appear, and approved conditional dismissals when negotiated schedules offered a workable alternative to judgment. In the Avalon matter, he refused the landlord's ex parte order as drafted, directed coordinated county access, protected the tenant's opportunity to remove belongings, and preserved the landlord's ability to secure the damaged unit. He also left the jurisdictional dispute for later, rather than deciding it without argument. The broader lesson is procedural. Appearing in court changes the available options. Tenants who appeared could explain payments, correct balances, request coordination, or document assistance. Those who did not appear faced default judgments based on the landlord's sworn proof, although some could still seek relief through payment or a forgiveness agreement. New rent can post before funding arrives, pushing a balance above an assistance program's limit. Promises must therefore be tied to dates and verified amounts. Did you notice how often the judge required payment before noon so the accounting could be updated before the hearing? Judge Simpson's approach balances possession rights with opportunities to cure, but an adjournment is not forgiveness. It is a short window to perform. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.